The prosecutors knew about a box of bullets that could have explained everything. They had it for 4 months. They filed it under a different case number so nobody would find it. And when the judge found out, mid-trial, she put on surgical gloves, walked to the evidence table, and opened the box herself. 8 words ended the case. Your motion to dismiss with prejudice is granted. This video is not going to make you angry at Alec Baldwin. It's going to make you angry at the people who were supposed to find out what really happened, and decided instead to hide the answer. The story you know goes like this. Hollywood star shoots someone. System tries to hold him accountable. Celebrity gets away with it. That story is incomplete. And the part that's missing is the part that should concern all of us. Because the same prosecutors who buried that evidence, nobody did anything about it. Halyna Hutchins was not a prop in Alec Baldwin's story. She was the director of photography on Rust, the person responsible for what every frame of that movie would look like. She grew up in Soviet Ukraine, on a military base in the Arctic Circle. She moved to Los Angeles, earned a film degree, and spent over a decade working her way up through the industry. In 2019, American Cinematographer magazine named her one of the industry's rising stars. She had a husband, a 9-year-old son. On the morning of October 21, 2021, the film's camera crew walked off set. They were protesting unsafe conditions, specifically the handling of firearms. Management responded by hiring non-union replacement crew. That afternoon, during a rehearsal inside a wooden church set at Bonanza Creek Ranch, the armorer Halyna Gutierrez-Reed prepared the gun. The assistant director David Halls took it from her cart without a full safety check, called out "cold gun," the industry phrase meaning "it's safe," and handed it to Alec Baldwin. The gun fired a live round. Halyna Hutchins was struck. She died before reaching the hospital. The FBI would later confirm the gun couldn't fire without the trigger being pulled. Baldwin had always maintained he never pulled it. In 1963, the U.S. Supreme Court decided a case called Brady versus Maryland. The ruling established a simple but fundamental rule. Prosecutors must hand over any evidence that could help the defense. Not just evidence they think is relevant, any evidence that might be. The legal term is exculpatory evidence. And under Brady, if the state suppresses it, even accidentally, the defendant's constitutional rights have been violated. On March 6, 2024, the same day Halyna Gutierrez-Reed was found guilty, a man named Troy Teske walked into the Santa Fe County Sheriff's Office. Teske is a retired law enforcement officer. He's also a close friend of Thel Reed, a legendary Hollywood armorer, and the father of the woman who'd just been convicted. He brought a box of ammunition. Specifically, cartridges with Starline brass casings and nickel-plated primers. The forensic record already showed that the bullet that killed Halyna Hutchins had a Starline brass casing with a nickel primer. The ammunition Teske brought matched. He believed it came from Seth Kenney, the props supplier for Rust, not from Gutierrez-Reed's personal supply. He thought it could show that live rounds entered the set from a source the investigation had never properly examined. Here is what the Santa Fe County Sheriff's Office did with this information. They cataloged it. Under case number 24-001099, not under the Rust investigation. A separate case number, created for this delivery alone. The Rust case had its own number, one that the defense legal team actively monitored. This new number, they had no reason to look for. During a pretrial evidentiary hearing in April 2024, the defense was shown the ammunition from the set. The Teske ammunition, the evidence that could have pointed to an alternative source, was not shown. The trial of State of New Mexico versus Alec Baldwin began on July 9, 2024. The prosecution's theory: Baldwin was not just an actor, he was a producer on Rust. He created the unsafe conditions. He pointed the gun at crew members with his finger on the trigger. He was responsible. 2 days in, defense attorney Alex Spiro was cross-examining Marissa Popple, a crime scene technician with the Santa Fe County Sheriff's Office. He asked her about the ammunition delivery. Popple confirmed. She had received a box of ammunition from Troy Teske. She confirmed it had been filed under a separate case number. She confirmed she had done so under supervisor's instructions. The prosecution had known about the Teske ammunition since March. They had not disclosed it to the defense. The following day, July 12th, something almost unheard of happened. Special Prosecutor Carrie Morrissey, the lead attorney for the state, took the witness stand herself, under oath, during a live trial. She testified that she had known about the Teske ammunition. She said she believed it wasn't relevant. She said it was her professional judgment that the defense didn't need to see it. Her co-prosecutor, Erlinda Johnson, resigned during the recess. Outside the courtroom, Johnson said she had argued internally that the state should have voluntarily dismissed the case. She hadn't won that argument. Judge Mary Marlowe Summers suspended the trial. She called for the evidence to be brought before her. She put on blue surgical gloves. She cut open the evidence bag herself in open court and examined the cartridges. 3 rounds, starline brass casings, nickel primers, matching the forensic profile of the fatal round. The judge concluded, these were materially similar. They were relevant. They should have been disclosed. On July 12, 2024, Judge Summer dismissed the case against Alec Baldwin with prejudice. That phrase matters. With prejudice means it can never be refiled. The charges are gone permanently. She issued a 21-page written order. She cited 2 doctrines, Brady v. Maryland and Rule 5-501 of New Mexico's Rules of Criminal Procedure, the state-level obligation to disclose all material evidence. There is no way for the court to right this wrong. The sanction of dismissal is the only warranted remedy. Judge Mary Marlowe Summer, July 12, 2024. If this conduct does not rise to the level of bad faith, it certainly comes so near to bad faith as to show signs of scorching. Judge Mary Marlowe Summer, July 12, 2024. Here is the part of this story that gets very little attention. Hannah Gutierrez-Reed, the armorer, was convicted in March 2024. She was sentenced to 18 months in prison, the maximum, and began serving immediately. After the Baldwin case collapsed and Morrissey's misconduct became public record, Gutierrez-Reed's defense attorneys argued that the same Brady violations had occurred in her trial. The judge reviewed the claim. She found that yes, some evidence had been withheld in the Gutierrez-Reed case too, but ruled that the defense hadn't demonstrated it would have changed the outcome. Gutierrez-Reed was released on parole on May 23, 2025, after serving 13 months. Her appeal remains active. Troy Teske, the man who delivered the ammunition, said publicly, "It bothers him that Baldwin is free and Gutierrez-Reed went to prison, even though the evidence that could have helped her was buried in both cases." Brady versus Maryland is 62 years old. Courts have affirmed it thousands of times. It's as settled as constitutional law gets. And yet, in a case with international media coverage, multiple special prosecutors, unlimited resources, and a judge actively watching, the prosecution still managed to file exculpatory evidence under a different case number and almost get away with it. The question is not whether Alec Baldwin is guilty or innocent. The question is, if this can happen in the most watched trial of 2024, what happens in the cases nobody is watching? My read on this is straightforward. Halyna Hutchins was killed. Somebody is responsible for the conditions that made that possible. That question, the real question, was never answered in court. Not because of Alec Baldwin's lawyers, not because of a technicality, because the prosecution decided unilaterally that a box of ammunition pointing toward an alternative supplier wasn't worth showing to the other side. That's not an accident. Filing evidence under a separate case number takes a deliberate choice. Someone looked at that box of cartridges and thought, I don't want the defense to find this. And here's what I find genuinely alarming. As of today, nobody has been disciplined. Carrie Morrissey tried to appeal the dismissal. The New Mexico Attorney General declined to pursue it. She withdrew the appeal in December 2024. The New Mexico Disciplinary Board has not acted. The State Ethics Commission has not acted. The mechanism that failed here, the Brady obligation, exists specifically to protect the innocent from overzealous prosecution. When it fails in a case this visible, with this much scrutiny, and still no one faces consequences, that's not a flaw in the system. That is the system working as designed for people with power. Brady gave us the rule. Nobody gave us the enforcement. If this surprised you, not the outcome, but the mechanics, the next case goes further. We're looking at a doctrine that lets courts ignore your constitutional petition based on how you asked the question, not what you asked. How? Subscribe if you want to understand how the system actually works, not the version from civics class, the version from the case files. And drop a comment with your answer to that last question. What would justice look like?